Hey, everyone. Thank you for joining us today. We'll be talking about factors that in-house counsel should consider when deciding on whether or not to embark on an affirmative litigation program and whether such a program would be a strategic fit for your company. My name is Wendie Childress. I'm an investment advisor with Validity Finance, which is a commercial litigation finance company dedicated to fair funding practices that build trust. I've been with Validity for almost 4 years. Prior to joining Validity, I was a commercial litigator with Yetter Coleman in Houston for nearly 17 years. And I'm happy to be joined today by Derek Ho, who I'll let introduce himself.
Hello, everyone. My name is Derek Ho. I'm a partner at Kellogg, Hansen, Todd, Figel, and Frederick. We're a litigation firm based in Washington, D.C. I've been a lawyer there for about 20 years. My practice focuses on bringing claims on behalf of plaintiffs in a wide range of types of cases, including both in the class action context as well as individual plaintiffs.
Thanks, Derek. So to get us started, I thought we might just talk a little bit about what an affirmative litigation program is in your experience and what you've seen with your clients.
Sure. Thanks, Wendie. In my view, at the very highest level, an affirmative litigation program is a program by which a company begins to view litigation not just as a necessity, but as an opportunity. Obviously, any company could be faced with the need to engage in litigation as a way to vindicate a violation of its rights. If your trade secrets are stolen, you might need to engage in litigation as a plaintiff in order to recover. But an affirmative litigation program is somewhat different in the sense that it views litigation as an opportunity, as an economic opportunity to generate revenue for the company. And I think there are multiple flavors of affirmative litigation programs. Some of them are situational. Nowadays, there are more and more class actions in which large companies are included in the putative class, whether it's an antitrust case or some other kind of case. And a company faces a choice in that context whether to try to vindicate its rights through the class action mechanism, in other words, stay in the class, or whether to bring its own claims outside of the class context by hiring its own lawyers, paying for its own experts, etc. And that is a choice that one has to make in the context of a class action. And so there are situations in which a company is required, in essence, to decide whether it wants to be an affirmative litigant or have its claims brought on its behalf. I think there are other contexts where, even more broadly, a company may decide to investigate affirmative claims and potentially bring affirmative claims that other people are not bringing on its behalf. So I think there are multiple flavors of affirmative litigation programs, but I think conceptually what we're talking about is, should a company begin to look at affirmative litigation, i.e. becoming a plaintiff, as not just a necessity, but an opportunity? Wendie, I know you have a lot of experience with advising clients about these issues, so I wonder if you could speak to the kinds of considerations that in-house lawyers at companies ought to take into account in deciding whether an affirmative litigation program is right for them.
Sure. And also to your point about these types of programs, one thing that we're seeing a lot are companies where they might have very valuable IP. And so the consideration is, do we actually affirmatively pursue our rights vis-a-vis the IP, or ongoing business relationships where there's kind of a consistent problem, whether it's a supplier relationship or other types of relationships? Do we risk the business relationship and sue these counterparties, or do we not? So these are issues that we're seeing clients face more and more. But of course, in-house counsel faces a number of pressure points in managing their litigation department, even in the best of times. And certainly when there are economic pressures like we're seeing today, we're hearing in-house counsel say we have to do more with less these days. outside counsel costs are rising dramatically. I think they were up 11% in 2021. You've got inflation, other economic pressures, a complex regulatory landscape. And so in-house counsel is kind of constantly looking at the budget and trying to figure out, even just in that reactive space, how are we going to pursue our rights or defend against claims made against us. And so they have to balance those pressures with the benefits that may come from pursuing an affirmative claim. So how can they do that? One thing that we see kind of affirmative, proactive in-house counsel doing is they'll kind of look beyond what are the immediate emergencies that I'm facing, what am I defending against, and they'll look to the business units and actually engage them to be claim finders. They'll ask their business clients, what are challenges that you're facing? Are there causes are there causes of those challenges that could be addressed? Are they being caused by, are we having increased costs that we shouldn't be burdened with because of contractual counterparties or business partners? Have there been claims that we had in the past that we probably should have pursued, but we didn't because we just were so concerned about keeping our budget down? Are there others in our industry that are pursuing claims that we should be pursuing as well? And then I'm going back and I'm looking at my budget as in-house counsel. And of course, there's tremendous pressure to keep budgets down or flat. And so I have to weigh the possibility of unlocking good claims that generate revenue against that budget. And so these are sort of this is the back and forth that we see in-house counsel facing kind of on a daily basis.
I completely agree. And one thing that I might add as well is that when I talk to in-house counsel about the possibility of bringing these kinds of claims, another thing that I think it always weighs on them is the risk, uncertainty, and delay involved in litigation. Mm-hmm. The reality, unfortunately, is litigation takes a very long time, and in addition to being costly. And so part of the problem, I think, that in-house counsel faces in promoting the idea of an affirmative litigation program inside the company is that oftentimes the prospect of recovery is years in the future, when the business side of the house is thinking about the immediate needs of the business in often very difficult economic environments. And so one thing that makes it difficult, I think, for companies to sort of adopt affirmative litigation programs is that it's often hard to justify sacrificing immediate business imperatives in the name of recoveries that may be far off into the future.
That's a very good point. It's kind of a mismatch between looking at this year's costs and revenues and something that may not come to fruition for many years into the future and may feel a bit risky or uncertain. And I think to that point, and just generally, often in-house legal departments are viewed as a cost center. And so the pressure really is keep those costs down rather than seeing them as a potential to pursue revenue generating claims. And so these are the factors that in-house counsel has to weigh in trying to even determine if they have the ability to go forward. However, there are benefits to doing so if you can kind of address those pain points. As you mentioned, there may be very valuable claims that the company has, and you have an ability to unlock them and generate a large damages award or a favorable settlement. And then you're bringing in money into the company when it otherwise is facing a tough year, or it's otherwise viewing your department only as that cost center and not as a way to affirmatively grow the company.
I agree. And for example, from a litigator's perspective, one way to try to make affirmative litigation more attractive is to find creative ways to structure the litigation so that it creates the possibility of early recoveries. If it's a single claim against a single defendant, and that defendant is well-resourced and likely to fight long into the litigation, that's not likely to generate a recovery anytime soon. But in the antitrust space, to take an example, if you sue 10 different defendants for an antitrust violation that carries joint and several liability, there is a litigation strategy whereby you can begin to generate recoveries early on by strategically settling with some defendants earlier on, and then reserving, cases that or claims against certain defendants that might be the most promising to trial. So I think that one of the objectives of in-house counsel who are thinking that affirmative litigation programs might be a good fit for the company is to try to find litigation strategies that actually address some of the pain points that we've just been talking about.
I think that's right. I think, in order to be able to do that, of course, you're going to want to have the ability to hire, the very best counsel of your choice. You're going to want to have a trusted partner that helps you determine whether or not any particular litigation is worth pursuing. And then, of course, the strategy and how to do so. And so that's a very important role that your partner and your outside counsel play for the company.
Wendie, what are some other ways that in-house counsel can pursue an affirmative litigation program while trying to minimize some of the pain points that make it perhaps hard to sell the idea in-house?
Well, so often, and I know you've seen this in your practice as well, often companies will approach outside counsel with a request for an alternative fee arrangement. That may be capped fees, that may be in the form of a contingency arrangement where they're asking the firm to take on the risk in terms of their hours of whether or not they're going to recover. Some firms are willing to do that. Some firms do that very well, but often firms, especially these days, who are facing similar economic pressures to companies, aren't wanting to take on that full risk. And so they're either saying no to their clients or they're pushing back in one way or another. And that is where litigation funding can come in to kind of bridge the gap between the pain point of the in-house counsel who has a real pressure to keep their budgets low and divert capital elsewhere, and then the firm who has pressure to generate revenue as well and is looking at their books on a yearly basis and can only take on so much risk. So funding is a mechanism where a third party comes in and they're able to provide funding to that client or company in the form of fees or costs so that they can pursue the litigation. So the company is not facing a capital outlay by paying their lawyers. The firm is not taking on the full risk of the litigation in the form of a contingency. And so the funder comes in and covers those costs of litigation. And importantly, it's done on a non-recourse basis. And so if the case is successful, the funder will recoup the money that they've spent to pay the attorney's fees and the cost of litigation, expert costs, et cetera. They'll recoup that money along with the return. Ideally, and this is the way we do things at Validity, the client is still recovering the bulk of any damages that are earned from the litigation. So the client is really in the same position as they would be if that firm just took the case on a contingency. So 50-60% of case proceeds going back to the client, and that the litigation department is able to say, we've generated this money for the company. The attorneys are recovering, and then the litigation funding company will recover a return as well. If the case is unsuccessful, the attorney is not paying anything beyond whatever their pre-negotiated contribution of time was. The company is not paying legal fees and costs. It's really the funder has incurred that risk and taken that risk off the shoulders of the company. And so it's a way to unlock these valuable claims and pursue an affirmative litigation program, but you've completely eliminated the pressure point of increasing your litigation budget and using company capital to pursue litigation, which might not be seen as a favorable option to your business client. And one thing I'll add is this can be done on kind of a single case basis where the company has just one claim that they're looking to pursue. And then sometimes we're providing capital to a company in a portfolio. So it's a kind of a number of cases, and the funder comes in and provides the fees and costs. And as those cases resolve, if they're successful, that's how the funder is recouping its investment. But Derek, I wonder if you've seen some of these type of programs be successful in your practice.
Definitely, yes. And I think that more and more companies are beginning to realize that litigation is an economic opportunity, that when pursued in a smart, careful way, pursuing meritorious claims, that affirmative litigation programs can allow the legal department to become a generator of revenue as opposed to a mere cost center. And I think that more and more companies are pursuing this, and as they do, more and more companies are getting comfortable with the idea that pursuing affirmative litigation is not something that's, just for class action plaintiffs' lawyers. There are legitimate and important benefits to pursuing litigation in the right context, in the right cases, for even the largest companies.
Well, thank you so much. There's much more to say about this, but we're at the end of our time. I want to thank everyone for joining us. We'll be providing our contact information along with this video, so please feel free to reach out if you have questions or want to talk about this further with us. Thank you so much.
Thank you.